Good morning, everyone, and welcome back to our weekly webinar series. Today, we are having our 145th episode. Over to Anil sir.
Thank you very much, Ankit. So, in this 145th episode, we are focusing on the various uh, company law provisions which got amended along with the Insolvency and Bankruptcy Code promulgation. What is their impact? We are also discussing various notifications issued by Ministry of Corporate Affairs, may it be for filing of documents, facilitating insolvency professionals to comply with the requirements of Companies Act, or even various other notifications for implementation of the Insolvency and Bankruptcy Code. Okay, so we are what we actually are discussing today is as I said, the key amendments to Companies Act and MCA notification and some of the judicial pronouncements. So when we actually see in this 145th episode, why we thought of this, because we actually could see some of the notifications which have actually escaped the attention, at least escaped the attention of the professionals, at least to our knowledge. So therefore, we thought that it is one episode which is focusing on various amendments to the Companies Act and also to the uh, MCA filing procedures and processes. So when we actually also, while we were studying this, we also saw that how this evolution of insolvency and bankruptcy law in India has actually been through. In like 1964, 24th Law Commission was set up, and that actually for the purpose of amendments to the Provincial Insolvency Act 1929, and of course that could not provide us any significant results. Then in 1981, a Tiwari committee was set up, and out of that committee, the mandate given was how to protect industry from the creditors. So the mandate given was the the SICA, the Sikh Industrial Units. SICA 1983 came into the law, so that remained effective for more than 20 years. But of course, everyone knows that the SICA was being used by the promoters to protect themselves from the creditors, and also they were enjoying the moratoriums. They were having the control. So that was the debtors in possession regime of India that India has seen for more than 20 years under the SICA through BIFR. Then in 1991, Narasimhan Committee 1 was set up. How basically, when this SICA came, the BIFR was in fact instrumental more in protecting the companies and promoters from the creditors, but the recovery process was slowed down and the NPAs were in fact ballooning. So therefore, the outcome of Narasimhan Committee 1 came as the Recovery of Debt Due from Financial Institutions Act 1993, and that actually came with the setting up of the special tribunals, which is debt recovery tribunals. So that was the outcome of Narasimhan Committee. Then we also had this in 1998 when we saw that this debt recovery tribunals, in fact, their recovery department that was set up under the debt recovery tribunals, that was not really very effective, and the banks were struggling to recover their dues. So therefore, the Narasimhan Committee 2 suggested SARFAESI Act. That was in 2002 when the SARFAESI Act came. So in fact, a lot of work that we started under the SARFAESI Act that also is the kind of advantage that we got as AAA group, as a advantage of first mover, so that we got. So today we are the largest uh, uh, enforcement agents in India under the SARFAESI Act, where we are empaneled with most of the banks in India. Then in 1999, this Justice Iradi Committee was set up. So, in fact, in that particular committee, it was suggested that the SICA should be repealed and the BIFR should be repealed. And in 2001, Alan Mitra Committee came with this. They proposed that we should have comprehensive bankruptcy code. And in 2005, Irani Committee was set up. So then, in that particular scenario, the in 2005, some major amendments were suggested in the SARFAESI law and also in RDD BFI law. So this was the then finally the Raghuram Rajan committee that was set up in 2008. So this they proposed improvements to credit infrastructure, and in 2014 bankruptcy law reforms committee was set up, and insolvency and bankruptcy code, the that in fact came replacing the various other laws. So that was one insolvency law, a evolution of insolvency law that we could see. See, when the insolvency law was promulgated as a result of various reports, various committees, their observation was that in that scenario, in that regime, there was overlapping jurisdictional and legal uncertainty was the challenge before the economy. There was BIFR, then under SICA, then there was the Recovery of Debt Dues from Financial Dues to Financial Institutions Act, RDD BFI Act. Then there was SARFAESI Act. So then there was other like the Indian Penal Code and the Indian Contract Act, the kind of so Arbitration Act. So the creditors were actually completely confused because of the overlapping jurisdiction and kind of window shopping before forum shopping. So that was all going on. Secondly, the government of India also got a feedback that there is no exit route in India. Once a business is started, there has to be an exit route. So that exit route was missing, and the winding up processes, as mentioned in the Companies Act, was very slow. It was very tardy. So that also was one of the trigger that the exit is a right of an entrepreneur, that in case the business fails, he should have a right to exit. Then like the in a scenario, it was felt in any economy globally that there are circumstances where the business entities would require a kind of debt restructuring rather than enforcing the security interest. In case the debt is restructured, then in that case there is a possibility of revival of the company and the recovery of full amount rather than enforcing the securities and coercive actions. That was also one of the need. Then the entire economy was one based on all these reports that we discussed. They were feeling that the creditors have no control on the business. The court processes are lengthy, procedural. However, the creditors have no control on the business. There was no possibility that the creditors can take over the business which they financed. That was also one lack, or one like kind of that was also not available. Then it was also felt that the government should have power to create some kind of special mechanism for MSME, which is the backbone of Indian economy, because of the one, that it generates a lot of GDP, employment, and also the competition to the larger organizations. Otherwise, there are possibilities of monopolistic scenarios. Then there was hardly any law for cross-border insolvency, and the existing law, some kind of the facility, the kind of options available for cross-border insolvency or recovery, that was also almost insignificant, and the liquidation procedures were not, in fact, very, very certain. So when this insolvency law came along with this, we will see that some of the changes that the companies law was also immediately, as on the promulgation of IBC through Insolvency and Bankruptcy Code, through the same act, the various provisions of the companies law was also changed. First is the company liquidator under the Companies Law, referred to a liquidator appointed by the tribunal for the purpose of winding up of a company under the company law provisions. So it was governed primarily by Chapter 20 of the Companies Act, dealing with winding up proceedings initiated before the tribunal. So then, when this IBC came, the definition of company liquidator, this was updated to align with the new IBC law. The term now includes the company liquidator would mean resolution professional and the liquidators appointed under Insolvency and Bankruptcy Code for handling the resolution processes or liquidation processes. So this in fact resulted in the change in the Companies Act. Then we also had a change in the winding up processes, and winding up in fact it was referring to a legal process by which the company ceases to exist and its assets are liquidated to pay creditors, with the remainder distributed to the shareholders. This process was strictly governed by the Companies Act, and it was through the winding up was through the high courts of the jurisdiction in which the company falls. Then the winding up process was applicable to certain scenarios. One, that the company's inability to pay debt. Then a special resolution by the shareholders have been passed for voluntary winding up of the company. Third, tribunal ordered winding up for just and equitable reasons. The companies were being wound up for three reasons. One, inability to pay debt. Two, the shareholders decided voluntary winding up. Three, that the tribunal ordered winding up for just and equitable reasons. And then what happened post IBC? The winding up under the Companies Act now largely exclude processes related to insolvency, which are now governed by IBC. Even the term winding up under the Companies Act is reserved for cases not covered by the IBC. The voluntary winding up, separately, it is covered under the IBC. The winding up, which is the insolvency winding up, that is covered under IBC. But some certain powers of winding up or liquidating a company still lies with the tribunal under the Companies Act. That means the national NCLT, so that tribunal can actually say the compulsory winding up initiated by the registrar of companies or any authorized entity for reasons related to insolvency. That kind of compulsory winding up is also in the powers of the NCLT under the Companies Act. Then the voluntary winding up not involving the let me try. So now section 253 to 269 of the Companies Act was dealing with the revival and rehabilitation of sick companies, and it is applied to companies where they were financially sick and unable to pay debts. So the process in process was that the company or its creditors should apply to NCLT for declaring a company as a sick unit. If the tribunal was satisfied, then it would order the preparation of a revival plan and then appoint an interim administrator. Then they require the revival plan required the creditors to approval of the approval of the tribunal. So this was the one pre-IBC sections 253 to 269. When this IBC was promulgated, these sections were omitted from the Companies Act. Section 253 to 269 were omitted from the Companies Act, and all this jurisdiction was transferred to NCLT, and then the IBC now applies to companies both which are financially distressed and insolvent, limited liability companies, partnership, and some specific individuals who actually have given a guarantee to a corporate loan, and the limit was 1 crore. Default limit is kept 1 crore, and the uh, creditors or even the company can initiate the process, but that is what is the uh, uh, present law. Then the another amendment was under Section 8, subsection 9 of the Companies Act, that is regarding the Rehabilitation and Insolvency Fund. Rehabilitation and Insolvency Fund, in fact, when we see the Insolvency and Bankruptcy Code, we can also see that there is Section 224 in the IBC, which actually talks about Insolvency and Bankruptcy Fund. Under the Companies Act, it was Rehabilitation and Insolvency Fund. However, under Section 224 of the IBC, it is the Insolvency and Bankruptcy Fund. And so far, I have not seen I have not seen any kind of fund which has been notified in this manner. So that is something which is so it is not seen as of now. Uh, the no fund has been notified under Section 224 of IBC, which is named as Insolvency and Bankruptcy Fund. When I see the contents of Section 224, the contents of Section 224 are like this: that the anyone who is a debtor, and then the debtor can take the membership of this fund, and the debtor can contribute some amount to the fund, and when the debtor is in difficulty, then that money can be claimed by that debtor. So that kind of fund was proposed under Section 224, and earlier under the Companies Act, it was a Rehabilitation and Insolvency Fund, but no such fund has been notified, even if we have seen the amendment, but nothing has been notified so far. Similarly, we also see under the Companies Act, the voluntary winding up was allowed, and similar, the voluntary liquidation is called. Similarly, in under the IBC, also the voluntary winding up provisions were omitted. However, the voluntary liquidation provisions are now governed by Section 59 of the IBC. The Insolvency and Bankruptcy Code, in fact, introduced a structured, time-bound process for voluntary winding up, requiring the involvement of an insolvency professional and adherent to the creditor-centric procedure, ensuring greater transparency and accountability. So, therefore, the reasons for voluntary winding up and special processes under Section 253 to 269, 304 to 323, and 325 was in fact repealed. Then another amendment is regarding the tribunal's jurisdiction under the Companies Act was limited to winding up proceedings initiated under the specific grounds. Post IBC, the tribunal's jurisdiction has been expanded to cover all matters related to winding up, and including claims, disputes, and asset-related issues under Section 280 of the Companies Act and various sections of the IBC. So now the tribunal can even decide to liquidate the companies under the Companies Act, and as an adjudicating authority under the IBC, the adjudicating authority, which is the same NCLT, can also order liquidating a company based on the debts are not being served. So then we also have an amendment under the Companies Act, like we see Section 326 and 327, prioritizing the workmen's dues and secured creditor in winding up cases. So now, since the all these priorities in the case of liquidation or winding up or sale of assets, these are governed by Section 53. So therefore, the Section 326 and 327 are not applicable as far as these companies which are under insolvency or liquidation under the Insolvency and Bankruptcy Code. Uh, then we can see the transfer of cases. Like we actually can see Section 434 of the Companies Act, which was amended uh, in the IBC, and after that also it was amended for a immediately after 1 year. Now the earlier the before insolvency, the insolvency and liquidation cases were handled by multiple forums such as high courts, company law boards, and the district courts, creating delays and jurisdictional overlaps. Now, since the IBC has been promulgated and Section 434 has actually been inserted or amended in the Companies Act, it therefore now all the existing cases of winding up before high courts would be transferred to NCLT. Any other disputes will be transferred to NCLT. Any company law matters will be transferred to NCLT. And in Section 434, there was an amendment which was made in 2018. And by that way, if there are any cases which are pending before High Court, and then in those cases, any creditor can make an application to the jurisdictional High Court where that case is pending, so that that case can actually be transferred to NCLT and it can start from CIRP and not the winding up. Similarly, Section 419, subsection 4 of the Companies Act was also amended, where the central government, in fact, had taken the powers to establish additional NCLT tribunals as required, depending upon the capacity requirement. Then we actually can talk about the MCA notifications and circulars under the IBC. So, Ankit, we can take a pause here, and in case you actually can see, in case there are any things that you would like to add into this. So, I started with the various company law amendments which along with the IBC. In fact, as a part of the IBC, there were various other acts were amended, and today we are focusing on the amendments under the Companies Act, which actually through the Insolvency and Bankruptcy Code. And the most important is like the granting the powers to central government for additional NCLT tribunals, Section 434, where all the cases will be transferred on a request. So all the existing cases, wherever any jurisdictional high court on an application from a creditor, it can go to insolvency court and it can start from CIRP and directly will not go to winding up. Then we have the various other voluntary winding up provisions are all omitted, but the tribunal under the Companies Act, which is NCLT, still has the power to order for winding up of a company. And we also saw that the Section 326 of the Companies Act and 327 of the Companies Act also talks about the priority in which the proceeds of sale of assets would be distributed to the stakeholders. So this is what we have covered so far, and now we would actually be covering the various MCA notifications which are relevant to insolvency and bankruptcy code. Yes, Ankit, you would like to add? And
before we go forward, I can share one question. So Arun Kumar Srivastava ji, he's asking that presently which sections of Companies Act are applicable for rehabilitation, winding up, other than those dealt by IBC. So I can think of one. Of course, there is a process of strike off that is still available, and that's one of the ways where companies are effectively or practically wound up. And with respect to rehabilitation, you have 230 that talk about, where you have members and creditors working together and kind of bringing in a scheme of arrangement or a scheme of agreement between themselves to in some way revive a company. Anything else that you would like to add apart from these two that I can think of?
see, for debt restructuring, we still have Section 230, 231, and 232 of the Companies Act, which talks about debt restructuring or any restructuring arrangement with the members of the company. So that is where the voting is required from the creditors and also from the shareholders. But in case the company is in liquidation, then no approval is required from the shareholders. It is only and only required from the creditors. So therefore, Section 230 and 231 and 232, in fact, recently we concluded one case where the NCLTs approved our, this is called scheme of compromise and arrangement. So the NCLT approved in the case of Birla Kotsin. So it is in public domain. Everybody can see that the NCLT has approved a scheme of compromise and arrangement under Section 230 of the Companies Act while the company was under liquidation. So that is one section which is available. And the other section is where all the cases under Section 230, where these disputes are before the tribunal. If there are disputes which are before the tribunal, for example, the disputes regarding the shareholding, disputes regarding the mismanagement and operations, then the disputes regarding the assets of the company between the members or between the creditors. So those kind of disputes, in case those disputes are not resolvable, then the NCLT as a tribunal under the Companies Act has the power to liquidate the company. But in that case, whatever the liquidation would be, that liquidation would be handled through the liquidators. But then liquidation can be ordered by the NCLT for various disputes, as in case the disputes are not being resolved through any kind of orders.
So that's these are the questions that we had, and I think you can continue with the other topics, and we can request the participants to ask any questions or raise their hand in case they have anything to add.
So we have this MCA notifications. In fact, the notification, which was almost the first notification on 25th of October 2017 by MCA, and that was a kind of circular regarding the clarification. Because see, it was also raised, a lot of queries were raised to MCA that for any approval of resolution plan, whether the approval of the shareholders would be required, approval of the members of the company would be required or not. So this particular clarification was given by MCA that for the purpose of approval of a resolution plan under Insolvency and Bankruptcy Code, under Section 30 and 31 of the Insolvency and Bankruptcy Code, no approval is required from shareholders, even if their rights are restructured. No approvals are required from other creditors like operational creditors. Like, it will go as per the insolvency law. It will not go as per Section 230, 231, 232, wherever there is any restructuring, any compromise, any. So the shareholders' approval or the creditors' approvals are required. So whatever approvals are required, that will be exactly as per the Insolvency and Bankruptcy Code. That actually then we actually have the other notification, which is dated 18th of November 2019. So this notification is very important. Through this notification, the MCA, in fact, notified the insolvency and liquidation proceedings of financial service providers and application to adjudicating authority rules 2019 and the applicable regulations. Now, in this case, one thing that we all know, that while this IBC was promulgated, it was not within the powers of the creditors to initiate insolvency processes or resolution processes for all those companies engaged in or registered in India as financial service providers. Now, financial service providers are banks, uh, cooperative banks, Grameen banks, private banks, public sector banks, and it also the regional rural banks. So all these are considered as financial service providers. Then it is also applicable to non-banking finance companies, means NBFCs. So in the first time on 18th of November 2019, the government of India thought that there are some NBFCs which has actually become very large, and we have not given any power to any of the creditors to go to the insolvency court, and these companies are in fact insolvent, and they are continuing in the market, and they are continuing to misrepresent their financial status, and they are continuing to raise deposits and raise debts from the market. So therefore the government thought that it is important that we should bring these companies also to the insolvency focus. Now, what exactly the government did, that first, the financial service providers, so far there is no possibility of any bank going to insolvency. It is only and only applicable to NBFCs, and that too having an asset size of more than 500 crores as per the last audited balance sheet. Then only insolvency process of that NBFC can be started, and the Reserve Bank of India would be the regulator. So this regulator would be the Reserve Bank of India, but the regulations have been made and the rules have been made, and the accordingly some part of these rules, which are basically where the regulator is RBI, and some part of the other rules which are in fact made by IBBI as regulations. So this notification was also a very significant notification, where the insolvency of NBFCs, in fact, was initiated in November 2019, and thereafter you might have seen various large NBFCs has gone for insolvency, and that too triggered by our Reserve Bank of India, and also the administrator would be appointed by Reserve Bank of India, and no administrator can be appointed through, like, it is not the insolvency professionals qualification is not required for getting the appointment as the getting appointment as the administrator. Now, the next notification, which was also very important, on 15th of November 2019, that was the notification for the insolvency of personal guarantors. And all the relevant sections like Section 78, Section 94 to Section 187, they all were notified by this section. And in fact, also the rules were made by Ministry of Corporate Affairs, which is insolvency and bankruptcy insolvency. So those rules were also made for the financial service providers. Then we also have the notifications in this again. I think the notification that we're talking about now is when this total limit of default was increased to 1 crore, and that was done on 28th of March 2020. And then we also additional notification was required based on the feedback from MCA, and that was regarding the insolvency processes of the financial service providers. So in that case, the by this notification dated 30th of January 2020, the administrator appointed by the RBI and for under the rules which are made for the insolvency of financial service providers, it was also amended that the administrator has the power to recover receivables for third parties, and also administrator have powers to have the assets which belongs to third parties. Those are intact, and therefore the administrator would have the power to have that role of collecting receivables for third parties, and also protecting the assets of third parties which are lying in that bank or financial services provider as a kind of as a trustee. So therefore that is also one scenario where this receivables for third parties, it was not originally under the powers of the administrator, and now the assets belonging to third parties are also not in the powers of administrator. So with this notification on 30th of January 2020, it was made as administrator as power, as having the power for these two things. And then there was a notification on 9th of April 2021 saying that the default limit for pre-packaged insolvency resolution process is 10 lakhs, and it is not 1 lakh, neither it is 1 crore for pre-packaged insolvency resolution process. Then the notification also, like on 5th of September 2022, the Government of India decided to implement this Section 55 of the IBC. It talks about the uh, fast track CIRP. Now, in fast track CIRP, only 90 days are given for the entire resolution, and the like kind of then the notification, and then it was also declared that who are the corporate debtors which are covered under the fast track CIRP. So the Government of India took the power that the assets and income should be below a certain threshold, and the company should be MSME. And also later, even startup companies were added into this relief. See, what relief that we are talking about is this the fast track CIRP can be started for those companies where the asset size is below a certain threshold. I mean, presently, I think it is 2 crores. And then for small and medium enterprises, this was also considered as the a fast track. Then startup companies fulfilling certain criteria, there is a separate definition of startup companies where the benefit of this notification would be covered. So this notification is that the fast track CIRP would be applicable to these companies where the asset size is very low and the companies are MSME, and third, the companies are startup. Then we have this very important notification. In fact, for this notification, I would like to discuss the how the like government are normally uh, uh, very active in protecting some of the industries and making or making India as competitive as international market is. So in this amendment on 3rd of October, Ankit, we can take another pause for a minute in case there is anything that you would like to add on uh, these things.
Yeah, I think we can take some more questions. We have a few questions here. So we have Vikram Bhatnagarji. He says that I have been appointed as liquidator under section 270, 271, 272, read with 273. However, there are no funds. There are any funds in the company, even for the process and my fees. NCLT asked for details of action taken by me, which I have details of action taken by me, which I have done. The question remains, who will pay?
So Ankit,
So
I think this is very important that in case he can come and share his experience. So this experience that I would like that our audience should hear, this is an experience where the liquidation of a company has been ordered, uh, and Vikram Bhatnagar has been appointed as the liquidator, and how and under what sections the NCLT has the power to order liquidation of a company, and when the Vikram Bhatnagar has been appointed, so what are the difficulties that he has been faced? In case Vikram Bhatnagar can share his experience of working uh, as a liquidator, but not under IBC. Yes, Vikram.
Uh,
Vikramji, can you share your experience, please?
yeah, thank you. Can you hear?
Yes,
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 we
we
I'm
can
can.
audible?
hear.
Okay. Well, this order came on 19th April 2024, and I started the process. The public announcement had to be made, claims had to be invited. No claims were received. And when I visited the site, I found out that the company headquarter is was actually taken by them on rent earlier, long time back, some 10 years back. They had vacated, and there was another work activity happening there, not related to them. So I pasted my notification there also.
No, not like this, Vikram. I see. Under what was the dispute? What was the case before the NCLT, and under what circumstances they appointed you, and whether they were looking forward to an insolvency professional or any person can be appointed under such sections of Companies Act. Please,
Okay.
with this part is the first part, and then is the procedure part.
Okay.
Please.
Okay. Yeah, the appointment was because I was on the panel of IPs. So they picked up my name, the NCLT picked up my name from that panel and appointed me as liquidator for winding up the company under these sections of the Companies Act, and to follow the procedure laid down.
So what was the dispute? What was the circumstances that the bench thought that it is a case which should go to liquidation?
The company had itself applied for being wound up. Rather than go for voluntary liquidation under IBC, they applied for winding up under Companies Act. And they had no assets, there is no cash flow, no activities since the last several years. Only activity they had initially was lending to another sister concern from whom they couldn't recover. So that's it. Their balance sheets are virtually blank, full of receivables which aren't recoverable.
So according to you, that any company where there is no asset, there is no activity, can apply to the bench for such kind of winding up? And why
Yes.
this company could not go to voluntary liquidation? Because this company was not solvent. And
Yes, they were not solvent.
why this company was not first pushed to a CIRP rather than direct liquidation?
Yeah, that I don't know, but the company had directly applied to NCLT for being wound up. So they did not want to go for rehabilitation or resolution. There was nothing for them to resolve. They were only something like a shell company taking money from other of their associates and lending to another associate. This was the only activity, although it's registered as a shipyard, but they never did any activity related to shipping. They only borrowed funds and lent funds, associates.
So Vikramji, do you think that this particular option is available with all our professional colleagues, that some client comes to them and they want to say that we are not interested in striking of the name, because most of the international companies are not interested? Because striking of the name means that the company is inactive, but doesn't mean that the company has a the company can be revived whenever there is any liability which can be surfaced. So the striking of the name of the company from the register maintained by ROC is one step for all these defunct companies. And the second step is, like as Vikram Bhatnagarji is saying, that the tribunal under the company's law, under the section 268, can order for a winding up. Now, any professional can go and take this order. Vikramji, is it something which you can say something to our audience?
I don't know about the part whether a professional can seek such an appointment. Because in my case, the NCLT...
Not appointment, G, not appointment. I'm saying that any particular director, any management of the company, they have no two options. One is the going for voluntary liquidation, and the other is going for making an application under section 268 of the Companies Act to tribunal. Do you think that these are two options available now?
Yes, available. And this particular company, the promoters, they chose to approach the NCLT for getting the company wind up, and thereafter getting the name struck off from the registrar. Their intention is to dissolve the company.
And I understand that. Intention is to dissolve the company, and striking of the name from the register maintained by ROC is not a conclusive winding up. The company can be revived even within 20 years. I think Mr. Mahesh is also would like to say something about this only, in case he has to add something about this concept only.
Mr. Maheshwari.
I'm Lalit Maheshwari.
Lalit Maheshwari ji. See, in case you would like to add on this particular point, please.
Yes, sir. There are so many cases which were already pending with the high courts. They have transferred to the NCLT under section 434 without looking into the depth, whether they debt or not. So there are so many cases already. Now it is pending with the NCLT. Now NCLT is appointing such type of IPs to proceed further.
No, Lalitji, that is a different section 434 is very clear that wherever a winding up application is pending before the jurisdictional high court, any creditor can make an application to that jurisdictional high court, and that case will be transferred to NCLT, and it will start fresh as a CIRP assignment. And then the official liquidator appointed by the jurisdictional high court will hand over all the records and all the assets to the RP. And the RP will first try to resolve the company, and then in case it is not resolved, then it will be taken to liquidation. What we are discussing with Vikram Bhatnagar is that the company has applied itself to the NCLT tribunal under the Companies Act, under Section 268 of the Companies Act, that this company may be liquidated without going through CIRP. That is what is the main question that we are attending today, which Vikram Bhatnagar is saying, and he has the first experience of getting appointed from the tribunal. If you have that experience, so we would like that audience should be clear whether there are presently two options available for a company: one, to go for voluntary liquidation; other, to go for winding up directly under the Companies Act by making an application to tribunal under the Companies Act, which is NCLT again, under Section 268. So, Ankit, this is one thing that we actually have this as an option, and we can actually talk about it. Our team will also discuss whether this kind of option, if it is available, then it would be probably much easier for some circumstances. Some of the people would be able to say something. I think some
Ranjanji would also like to perhaps add something. Ranjanji, you can unmute and say.
Sir, am I audible, sir?
yes, you are.
Sir, actually, then the guidelines should be there that in which circumstances this Section 272 would be approved, would be allowed by NCLT, and who will bear the cost?
Exactly. That is my problem also.
So in case we are getting appointed in many cases where the company doesn't have any asset, after the CIRP, liquidators are being appointed, and the liquidators are not able to find any asset. Then in that case, if there is any claim which comes, all the claimants will have to bear the cost. In case there is no claim, then immediately the company can be dissolved by making one application. So what is the job of the liquidator which gets wasted? One, his appointment, some of the compliances which is required, like issuing notices in the newspaper, and then in case no claim comes, then making an application for dissolution. So these are the things which are at risk. These are the 3 or 4 investments that we do from our side. These are at risk. However, there is no such fund available in India which can actually take care and compensate such liquidators against their cost. That is very clear. But in case there is no claimant, then nobody would be there to reimburse. And in case there is no asset of the company which actually can be recovered, then there will be nobody to compensate the liquidator's fee. That is very clear. So far, the scenario is like this only.
So if the promoter had applied for that, so the promoter should come out with the cost also.
No, that of course, another application can be submitted to NCLT that since there is no asset, since there is no claimant, so the promoter should pay the cost, and that can be while we apply for dissolving the company. At that time, the court can order to the person who applied for it so that he bears the cost.
Yes, sir.
Yes, it can be done. Vikram, when you file an application for dissolution of the company, you can also present a kind of estimated cost, and the bench will order that the person who had actually filed this application would be bearing this cost. That's what I feel.
Yeah, thank you so much. Thank you so much. Yeah, I'll do that.
I'll take 2 seconds, sir. In many cases, High Court, in which the official liquidator was already appointed, were transferred to the NCLT. Now NCLT is not doing anything. What they should do, sir?
No, NCLT will immediately consider those cases as a fresh assignment of CIRP, and we have seen many such cases where the NCLT immediately will make it a fresh case of CIRP and will appoint an IRP. Then IRP will take all the control from the liquidator, official liquidator appointed by the High Court, in case it is already appointed. In case it is not already appointed, that means that the IRP will have all the powers as a normal IRP for taking control and custody of the business and assets. So the NCLT will only have to appoint the IRP in all these cases, and this is very clear. And if nothing is being done by the bench, then it can be mentioned and action can start. 434 is very clear that it will be considered as new assignment of CIRP once the case is transferred from High Court to NCLT. Yes, Ankit. Any?
So we have Mr. Sneha Sagar. I think we can just listen to what is the query there. And we have another comment from Sanjay Ji. Sanjay Ji says that isn't section 268 omitted? That's his question.
No, section 268 is not omitted.
And so I think that's it. So if Sneha Sagar Ji can unmute and speak out his question. I think that's about it then. I think there might be an error at his end because of which he
So there are few more there are few more notifications that I would like to share with the audience. One is the when this Jet Airways scenario or even Kingfisher scenario happened in India, at that time the international lessors who are engaged in the business of giving aircrafts on long lease, those lessors in fact found themselves in trouble as they were not able to take their aircrafts back to their country and back to their possession. So that was all. And the other was basically some mobile equipment which is normally available from in the international market on lease. So there is basically there is a Convention on International Interests in Mobile Equipment and the protocol to the Convention on International Interests in the Mobile Equipment on matters specific to aircraft equipment were adopted under the joint auspices of International Civil Aviation Organization and the International Institute of Unification of Private Law, concluded at Cape Town on 16th of November 2001. So there are many mobile equipments which are given to cross borders and which are given globally by some of the lessors, and different countries actually take those mobile equipment, and it is more specific to the airlines industry. It can be aircraft, it can be aircraft equipment, and then there is a convention. There was a convention in Cape Town, and in that convention, some countries have signed to that and acceded to the convention and a protocol by depositing with the International Institute for Unification of Private Law. The instruments of accession was signed by India on 31st of March 2008. When this Jet Airways scenario or even a Kingfisher, the international lessors put pressure on the industry that in case our aircraft or our aircraft equipment is not safe in India and we are unable to bring it back to our country, then we will not fund any equipment. We will not give any equipment on lease to India, or our risk factor would be very high, and our cost to India will increase. Therefore, the government thought it very clearly that this under section 3 of section 14 of IBC. Section 14 of the IBC is regarding moratorium, and section 3 actually gives powers to the government of India to notify if there are any transactions where section 14 subsection 1 would not be applicable. That means where the moratorium would not be applicable. So therefore, in this case, the section 14 subsection 1 would not be applicable to transactions or arrangements or agreements under the convention and the protocol relating to aircraft, aircraft engines, airframes, and helicopters, because these are the equipments which are available to India, which are available to Indian entrepreneurs on lease from global lessors. So therefore, the government, in fact, added one item that any transactions, any arrangements, any agreements pertaining to the convention and protocol relating to aircraft, aircraft engines, aircraft frames, and helicopters would not be applicable. So the moratorium would not be applicable. So any aircraft or of Kingfisher, Jet Airways, and that in case that is aircraft in India and there is a default, in payment of lease rentals, then the foreign lessors will have the right to take away, and this section moratorium would not be applicable to them. Then similarly, on another date, which is on 14th of July 2023, the government also thought the same thing regarding the transaction which involve production sharing contracts, revenue sharing contracts, exploration licenses, and mining leases under the Oil Fields Regulation and Development Act regarding the oil fields, and the any transactions, arrangements, or agreements including joint operating agreement connected or ancillary to transactions, arrangements, or agreements referred to in clause 1. So all these agreements would actually, the moratorium would not have any effect on those things. So then we also we have talked about this part we will be talking about in the next webinar. In fact, we are saying that in case there is any question, the other part that we wanted to touch base today, that the MCA has issued various other circulars and notification regarding filing of INC 28 and filing of documents through GNL 2. So that is what we actually wanted to share, but the time is a constraint today. That INC 28, what are the total guidance on INC 28, and what is the total guidance on GNL 2? Otherwise, there can be a huge penalties on the successful resolution applicant. In a process of implementation of a resolution plan, I found that in case I file all 5 years resolution in the financial statements and the annual reports, it would attract huge penalty, and therefore it is the only one option that I have is to file against GNL 2. So that practical difficulty that I wanted to share. However, the time is very less. Maybe that the next episode that we will try to cover that part, a very small part, like how the penalties of registrar of companies can be avoided by filing all the documents under GNL 2. In case we, after the resolution plan is approved, in case we file our INC 28 and then the power goes to directors of the company, then the ROC doesn't have any powers to waive the penalty which is imposed by ROC. So that is something, late filing penalty. So there is no power that the NCLT has for waiving the late filing penalty. So it is a caution to all my audience that all the documents should be submitted as GNL2 under the signatures of the RP, and all the compliance, pending compliance, should be done in this manner. Yes, Ankit.
I think we are good. So we have had a very interactive session today, and I think it's also time for us to close the session. And it's good to know that the practical aspects of this process from our participants as well, and also a lot of insight that I think all of us had with respect to this part of the consultation or process that we can kind of talk about with prospective clients.
Yeah.
Thank you, everyone, and
thank you very much.
Thank you so much.
As we always say, that it is our way of learning, so we also learn with this. And thank you for being with us. Thank you.